Protecting a tenant's deposit is a critical responsibility for UK landlords. The rules and regulations governing this process aim to safeguard both landlords and tenants, ensuring that deposits are handled fairly. Here's everything landlords need to know about protecting a tenant's deposit. Legal framework. The requirement to protect a tenant's deposit arises from the Housing Act 2004 and applies to assured short-hold tenancies in England and Wales. The regulations were introduced to prevent unfair practices and ensure that tenants' deposits are returned promptly and fairly at the end of the tenancy. Key requirements for deposit protection. Number 1. Approved tenancy deposit schemes. Landlords must protect a tenant's deposit in one of the government-approved tenancy deposit schemes within 30 calendar days of receiving it. There are two types of schemes: custodial schemes, where the deposit is held by the scheme itself, and insurance-backed schemes, where the landlord retains the deposit but pays a fee to insure it against disputes. Number 2. Government-approved schemes. Deposit Protection Service, the DPS. Custodial and insured. My Deposits, insured and custodial. Tenancy Deposit Scheme, TDS, insured and custodial. Prescribed information. Landlords must provide the tenant with certain prescribed information within 30 days of receiving the deposit. This includes the following: the contact details of the tenancy deposit scheme, the landlord's contact details, how to apply for the release of the deposit, information explaining the purpose of the deposit, and what to do in case of a dispute over the deposit. Let's look at the consequences of non-compliance. Failure to protect the deposit and provide the prescribed information can have serious consequences. Number 1. Penalties. The tenant can apply to the court, which may order the landlord to pay the tenant up to 3 times the deposit amount as a penalty. Number 2. Restrictions on serving a Section 21 notice. A landlord cannot serve a valid Section 21 notice to regain possession of the property until the deposit is properly protected and the prescribed information has been provided. Number 3. Tenant claims. Tenants can claim against landlords at any point during the tenancy and up to 6 years after the tenancy has ended. At the end of the tenancy, the landlord should return the deposit within 10 days of agreeing on how much the tenant will receive. Landlords can make deductions from the deposit for unpaid rent, damage to the property beyond normal wear and tear, or other breaches of the tenancy agreement. Dispute resolution. If there is a disagreement over the amount to be returned, the deposit protection schemes offer a free dispute resolution service to resolve disputes without going to court. Practical steps for landlords. Number 1. Protect the deposit promptly. Ensure the deposit is placed in an approved scheme within 30 days of receipt. Number 2. Provide prescribed information. Deliver the prescribed information to the tenant within the same 30-day period. Number 3. Keep records. Maintain records of deposit protection and communication with the tenant regarding the deposit. Number 4. Conduct a thorough check-in. Document the condition of the property with an inventory at the start of the tenancy to avoid disputes later. Number 5. Communicate with tenants. Keep open lines of communication with tenants regarding any potential deductions and the condition of the property. To summarise, protecting a tenant's deposit is a legal obligation that UK landlords must adhere to carefully. Compliance involves placing the deposit in a government-approved scheme, providing the tenant with prescribed information, and ensuring that deposits are handled fairly at the end of the tenancy. Failure to comply can lead to significant penalties, restrictions on serving eviction notices, and potential legal claims from tenants. By following the prescribed steps and maintaining clear communication, landlords can manage deposits effectively and avoid disputes.